All right. Welcome back to the first in a series that I think I'm going to do a series called Now That's What I Call Bench Slaps. You know, I'm sure you all get the reference. But so this is going to be a real quick one today. It's a 2-page bench slap from a federal judge in the Northern District of California. For those of you who are new here, hi, I'm Joe. I'm an attorney licensed in the state of Utah. This is an antitrust case about the proposed and failed merger of Kroger and Albertsons. I did take antitrust law in law school. It was a very interesting class. It's difficult. I've forgotten way too much about it. It's basically an economics class. But this is docket number like 200 or something. Like massive docket, years of litigation. This is the judge's final order denying the plaintiff's motion for summary judgment and granting the defendant's motion to dismiss this case as moot. The case is Christine Whalen et al. Versus Albertsons Company Inc. et al. So lots of plaintiffs, lots of couple defendants, Albertsons and Kroger. So we're just gonna blast through this order. It's brutal. I saw this on Reddit, and the Redditor had posted the entire order in the body of Reddit, and I thought I thought that was just their summary of the order, and I thought, wow, this is brutal. Only to find out it's the judge's actual words. So we're going to blast through that. Then I will discuss the legal ramifications, sort of why this is the law, but we'll blast through this first. So the plaintiffs filed a lawsuit alleging that a merger attempt by Albertsons and Kroger would violate the antitrust laws. The court dismissed the initial version of the complaint because the plaintiffs failed to allege Article 3 standing. That's Article 3 of the Constitution. You must have standing under Article 3 to file a federal lawsuit. The next version of the complaint again failed to allege standing, so the court dismissed that version as well. After the third version of the complaint was filed, the defendants filed another motion to dismiss. Before issuing a ruling on the motion to dismiss the third version of the complaint, the court stayed the case, put it on hold, put it on the shelf. The reason for the stay was that at least 2 separate lawsuits seeking to block the merger were filed by government entities in different courts. The first was brought in federal court in Oregon by the Federal Trade Commission, the Oregon Attorney General, and others. The second was brought in state court in Washington by that state's Attorney General. In both cases, the government entities succeeded. The courts entered injunctions blocking the merger. And in response, Albertsons and Kroger gave up. They have dropped their effort to merge. Now, the plaintiffs in this case have filed a motion for summary judgment, asking this court in Northern California to permanently permanently stop the merger that Albertsons and Kroger are no longer even pursuing. So it's moot. The plaintiffs further suggest that because injunctions were entered in those other cases, and because the proposed merger is dead, they are entitled to attorney's fees in this case as the prevailing parties in the litigation. At this point, here's the major bench slap. We've already had snark all through this, but this is that at this point, the reader may be asking, is this some sort of joke? It is not. The plaintiffs are actually making these arguments. The plaintiff's motion for summary judgment is denied. The defendant's motion to dismiss the case as moot is granted. Dismissal is without leave to amend. It's over. You have lost. Goodbye. I award you no points. You lose. It is so ordered. Dated February 3rd, 2025. Signed Vince Chhabria, United States District Judge. Oh, that was brutal. That was brutal. When courts bring out the snark, you know they are annoyed. They still have to be professional, but the court is not amused. So, getting to the legal analysis. So, this case was dismissed multiple times because the plaintiffs had failed to allege standing. So, in order to bring a case, you have to have standing, meaning you are the appropriate plaintiff. You have to have suffered an injury, not necessarily that you've been hurt. It could be financial injury. It could, but you have to have suffered the harm contemplated by the lawsuit. So I can't sue on behalf of someone else. I mean, I can be their lawyer, but if my dad, let's say, was ripped off by Albertsons, we don't have Albertsons in Salt Lake City anymore. They were sold off. I think there's in southern Utah and one in Tooele, I think. But if I still call the local grocery store Albertsons because I'm old like that. But if my dad were ripped off by Albertsons and they overcharged him for a crate of beer, he could sue. He'd have standing. I couldn't sue as the plaintiff because my dad was harmed by Albertsons. I don't have standing. Now, I could be his lawyer. I could not be the plaintiff. No standing. The case has to be an actual controversy. It cannot be moot. If the case is moot, there's no controversy for the court to decide on. So if Albertsons has already refunded my dad for the overcharge on the crate of beer, there is no controversy. It is moot. So I can't bring a case. He can't bring a case. And there's one other element. I'm having a brain fart, but that's okay because we don't care about it today. Now, there are a few workarounds for mootness, like certain cases involving pregnancy, since pregnancy is, a temporary condition, but has the potential to reoccur. The courts have kind of held special mootness standards for pregnancy cases, but Antitrust isn't pregnancy, so that's also irrelevant. So if Albertsons and Kroger are not trying to merge, there is no controversy. It is moot. So let's look. This is a good summary on the webpage for the Housefield law firm, which Housefield is, they're talking about a Seventh Circuit case. Albertsons is, well, the Northern California is Ninth Circuit, but this is still good. And we're just going to summarize a little bit of this. So the Seventh Circuit's recent opinion in Marion Diagnostic Center versus Becton Dickinson breaks no legal ground, but they remind attorneys that antitrust standing and Article 3 standing are distinct. So you have to have Article 3 standing to bring any case in federal court, at least in federal district court, since those are the Article 3 courts. Like bankruptcy court is Article 1 court, and so it has special rules, but you'd still have to have standing. But in addition to that, to bring a antitrust case, not only do you need Article 3 standing, you need antitrust standing. And so the concepts are often confused, including by the district court in this matter, in the Marion case. In the opinion written by Chief Judge Diane Wood, the Seventh Circuit panel took pains to clarify and reaffirm the distinctions. Ultimately, the panel agreed that dismissal was appropriate under both doctrines of standing. So in Marion, they dismissed both on Article 3 and on antitrust standing. So in sum, Article 3 standing is a constitutional doctrine. The Constitution limits the jurisdiction of federal courts to cases and controversies, and a plaintiff must establish 3 prongs of the standing doctrine to bring a claim in federal court. Article 3 standing applies to all federal cases, not only antitrust. Antitrust standing, in contrast, is a prudential doctrine developed by the courts. So it's not a constitutional doctrine. It's not a statutory doctrine. It's developed by the courts to aid them in determining standing for constitutional cases. It's common law. So it outlines who is the proper party to bring an antitrust case. As the panel described, antitrust standing, plaintiffs must show that they have suffered an antitrust injury and that they are the proper parties to bring suit. In Marion, antitrust standing turned on whether plaintiffs were proper parties to bring suit. Under long-standing precedent, the Supreme Court in the Illinois Brick case limited purchaser antitrust claims to direct purchasers, giving the first buyer from a conspirator the right to sue, and barring suits by purchasers further down the chain. So basically, in those cases, let's say if suppliers of Albertsons or Kroger, so if Totino's had conspired to commit antitrust in the frozen pizza space by merging with Red Baron. I don't know. They might be the same parent company. I really don't know and don't care. So if I'm wrong, this is just for illustrative purposes. And because of that merger, I, as the end consumer, end up paying more at Albertsons to buy a Totino's pizza. I can't sue Albertsons, but I also can't sue Totino's or Red Baron for conspiring to commit antitrust violations under either the Sherman Act or the There's the Sherman Act and another one. I told you it's been too long. But I can't sue them because I am not a purchaser from Totino's. Albertsons is the purchaser from Totino's. So they have to sue over the higher prices. So that's what that is. But that illustrates standing. But in the Albertsons case, you can't just have 30 different or 50 different antitrust cases, one in each state. You only need one. And so who is the most appropriate plaintiff? Well, if the Federal Trade Commission sues, they are the most appropriate plaintiff. They are the regulatory agency or the Department of Justice. They sort of have joint jurisdiction to bring antitrust cases, to enforce antitrust. So, and in this case, the FTC brought a case in Washington, or no, in Oregon. It was the Washington Attorney General and in Washington State Court, the FTC in Oregon court. So individual purchasers at Albertsons don't necessarily, they may be harmed, but they aren't the correct plaintiff. But we're going to look at one more document if it wants to pull up for me. Okay, so this is docket 120, I think. The order granting the motion to dismiss the first amended complaint. So it's the second dismissal, dismissing the first amended complaint. And it illustrates why these weren't the correct plaintiffs, and they never alleged properly that they were. Like, even if they could have been, even if they did have standing, they didn't allege that properly either. So let's just take a quick peek and then we're done. So the motions to dismiss are granted because the plaintiffs have failed to allege Article 3 standing. This order assumes the reader's familiarity with the factual allegations. I mean, we haven't read the factual allegations, but that's okay. The relevant law and the parties' arguments. The plaintiffs have again failed to provide enough information about their own situations to adequately allege that they are likely to suffer an injury from the proposed merger. Of the 24 plaintiffs, only a few allege that they have shopped at Albertsons or Kroger's store at all. And the allegations about those few plaintiffs barely say anything, simply intoning that they have shopped at the store in their area. Although elsewhere in the complaint mentions in passing that they shop at one of the stores. And they allege if the merger goes through, they will be forced to pay higher prices. But the plaintiffs say nothing about whether and how many alternative grocery stores options exist in the areas where they could realistically be expected to shop. This could affect the analysis of whether prices are likely to increase at the Albertsons or Kroger stores where the plaintiffs allege they have shopped. Even aside from that, the bare allegation by some plaintiffs that they have shopped at an Albertsons or Kroger store leaves many questions relating to the likelihood of actual injury unanswered. Do they still shop there? If so, Is it occasionally or regularly? Are there other reasonable options equally accessible to them? The plaintiffs also fail to account for the proposed divestiture plan. So selling off some of the stores. If I remember, they were going to divest some of the Albertsons to Publix or Piggly Wiggly or something. So other options. It might expand. It gives some shoppers an additional option. They sure, the Krogers and Albertsons in their jurisdiction have merged, but they had to divest some of them. So all of a sudden, Publix is now in the market. Thus, not only have they not suffered harm, they may have gained an advantage. So even though details are emerging about that divestiture plan, and even though it could result in stores where the plaintiff allegedly shop being divested by Albertsons and Kroger altogether, perhaps the failure to address one of these questions would not, on its own, support dismissal for lack of standing. But the failure to address so many means the plaintiffs have not adequately alleged that they are likely to be injured by the merger. So they're, basically they have failed to allege standing. They have failed to allege injury or potential injury, because to get an injunction, potential injury, potential, to get a temporary restraining order, you have to show potential injury. To get a permanent injunction, permanent restraining order, you have to show ongoing, the risk of ongoing severe injury, basically. And they haven't done that. They've just said, well, yeah, a third of us shop at Albertsons or Kroger sometimes. We have no evidence that prices will go up. We've provided no evidence of the lack of suitable competitors, the lack of suitable options for the consumer, because in order to be an illegal monopoly, in order to be an antitrust conspiracy, you basically need what's called market power. And what is market power? What percentage? I don't know. Like there is no bright line rule, as far as I remember, that if you have 50% of the market in this area, you are a monopoly, and therefore you're illegal. Now, back in the day, there was a lawsuit against Aspen, because there are 4 ski resorts in Aspen, and this was before Vail had taken over the ski resort world. Like Vail and Altera, I think, with a few Boynes sprinkled in, own almost all of the ski resorts now. But this was back in the day. And so there were 4 separate resorts in Aspen, Aspen, Snowmass, Buttermilk, and one other. And they sold one joint ticket for all of them. And so an antitrust suit was bought. It's like, do they have market power in skiing? Maybe in Aspen they do. Do they have market power in skiing in general? What are your other options? Can you go to Vail? Can you go to Breckenridge? Can you come here to Utah? So, there are geographic aspects of market power at play as well. But, the combined Kroger and Albertsons, if I remember, still would have had less market share than Walmart. So does Walmart have market power? Probably, if anyone does, but Walmart's not seeking to merge. Walmart isn't in a conspiracy to commit antitrust violations. Because here's the funny thing about antitrust. Having a monopoly is not per se illegal. Having an illegal monopoly is illegal. Now, Joe, that's a silly distinction to make. If having an illegal monopoly is illegal, then surely having a monopoly is illegal. But if you're not conspiring to obtain market power, that's not illegal. If you grow to achieve market power through organic growth by attracting the most customers without undercutting prices, that would be a conspiracy. But if you organically achieve market power, that's not an illegal monopoly necessarily. So Walmart just expanding is fine. Now, if they were to buy virtually any chain, that probably would not be fine. So, antitrust is a weird but interesting subject. It's a difficult subject. So, yeah. But that said, that early bench slap is really what we're here for, but me, I couldn't leave it at that. We had to look at why the bench slap was so brutal. So, basically, that's it. Do all the YouTubey things. Like, share, subscribe, bribe your friends and family to do the same, and I'll see you next time. Bye-bye.